नमस्कार डियर फ्रेंड्स। आज इस वीडियो में हम जो चर्चा करने वाले हैं उस सब्जेक्ट के ऊपर मैंने ऑलरेडी मेरे चैनल के ऊपर एक वीडियो बनाई थी, जिसका लिंक मैं आपको इस वीडियो के कमेंट बॉक्स में डालूंगा। हालांकि आज इस वीडियो बनाने का जो रीज़न है वह रीज़न इस तरह का है कि एक इशू जो मद्रास हाई कोर्ट के सामने एक केस में डिसाइड किया गया था, उस डिसीजन के खिलाफ में गवर्नमेंट सुप्रीम कोर्ट ऑफ इंडिया में जाने के बाद सुप्रीम कोर्ट ऑफ इंडिया ने उस गवर्नमेंट के अपील को, यानी कि स्पेशल पिटिशन को, इन लिमिन डिसमिस कर दिया। एंड दैट इज हाउ द डिसीजन ऑफ मद्रास हाई कोर्ट was upheld by the Supreme Court. However, the judgment of Supreme Court was in limine, that is without reasons, and therefore the Supreme Court had not given a reasoned judgment or reasoned order upholding what Madras High Court held in that matter. But ultimately, since it was upheld by the Supreme Court, the judgment of Madras High Court itself was relied upon by many employees in various states, including the state of Maharashtra, into tribunals like Maharashtra Administrative Tribunal, as well as Central Administrative Tribunal, as well as the Bombay High Court, including the benches of Bombay High Court at Nagpur, Aurangabad, Mumbai. And the issue is whether the employee who stands retired on 30th June is entitled to get annual increment with effect from 1st July. The government denied and refused to give such annual increment to all these employees who stood retired on 31st June, on the ground that on 1st July the employee was not in service. But the interpretation done by the Madras High Court was to the effect that the annual increment, though is to be given from 1st July, but it is actually earned by the employee during last year. That is, for example, if an employee is to retired on 30th June 2022, he would be entitled in normal circumstance. Uh, he is denied the annual increment on the ground that he retired because on 1st July 2022 he is not in service. So the court interpreted the provision that annual increment is already accrued to the employee. It has been already earned by the employee. Therefore, no matter whether he is in actual service or he retired, whatever has been earned by him, whatever has been accrued to him, must be given to him. And that is how Madras High Court held that the employee who stands retired on 30th June of particular year is entitled to one annual increment that falls due on the very next day, because it has been already earned by him. Now, relying upon this decision of Madras High Court, we had filed original application of 26 employees from the sale tax department of Maharashtra, and similarly there were some other individual applications filed by various employees, and the Maharashtra Administrative Tribunal had clubbed all these original applications and decided by one common order, on which I have already made a short video that under the caption of landmark judgment of MAT. And MAT followed the judgment of Madras High Court and then allowed the cases, including the case of mine, that is of 26 employees, also allowed by the respective benches of the High Court, following the same judgment of Madras High Court. As the High Court, and instead of following and implementing the orders, Maharashtra government filed SLP in Supreme Court, and that SLP also came to be dismissed in limine, that is without reason. Again, similar issue was decided by Allahabad High Court, and that matter also came to be challenged in Supreme Court. And in that matter, perhaps it was not brought to the notice of Supreme Court that the issue has been already settled, and two such SLPs have been dismissed by the court. And therefore, in Allahabad matter, Supreme Court granted stay to the judgment of Allahabad High Court, and the government of Maharashtra took benefit of that stay. And on that stay, Maharashtra government did not implement the orders of Bombay High Court as well as MAT Tribunal, directing the state to pay annual increment to the employees who retired on 30th June. Now, in between, recently, one matter came to Supreme Court from the state of Karnataka, where Karnataka High Court also followed the judgment of Madras High Court and directed the corporation, the particular corporation, to pay the annual increment to the employees of the corporation who retired on 30th June. And this matter was also taken up to Supreme Court by the respective employer. And fortunately, in this matter, Supreme Court upheld the judgment of Karnataka High Court by passing a reasoned order. And now, ultimately, with this order on judgment of Supreme Court, upholding the view of court, that is High Court, Karnataka High Court, Madras High Court, Allahabad High Court, Bombay High Court, that the employees who stood retired on 30th June are entitled to one annual increment. Now, this issue has been ultimately decided by Supreme Court. Therefore, now the government of Maharashtra has no pretext to prolong the implementation and execution of the orders passed by the Bombay High Court benches as well as the Maharashtra Administrative Tribunal. Now it has no option but to implement, else the government officers will have to be sent to jail in contempt proceedings, because various contempts are also pending in tribunal. But however, the tribunal as well as High Court did not take any stringent action on the ground that the issue is pending before the Honorable Supreme Court. Now, since the issue before Honorable Supreme Court has been decided finally, now government is left with no option. Now, recently, following the very view of Supreme Court, the Central Administrative Tribunal bench at Bombay also allowed around 193 cases at one stroke by one common order. All different cases coming from different employees seeking the same relief, that they are entitled to one annual increment because they stood retired on superannuation on 30th June. So with this, the issue has been finally decided. Now, the latest judgment of Supreme Court is a decision of two judge bench. In the normal circumstances, since it has been policy of the Supreme Court that the settled law should not be unsettled lightly, and therefore the any other matter either filed by this Maharashtra government or other governments, that is UP government, etc., and pending before other bench of Supreme Court. Now they will have to be also decided on the same line that Supreme Court decided in the case of Karnataka High Court. Now, of course, this is going to have some effect on budget of the respective governments, because there are many employees who retired long back, that is several years before. But with the judgment of Madras High Court, they came and filed the cases and they succeeded. And in various matters, High Courts have directed that not only that they are entitled to one annual increment, but they should be given even arrears for last 3 years. So when it comes to arrears, and once they are entitled to the annual increment, the departments will have to refix their last drawn pay, and accordingly it will result into enhancing the pension as well as other pensionary benefits also. Certainly this is going to be a burden on the state exchequer, but since it is a right under the law, and since we are living in a country governed by the rule of law, the decision of court is ultimately upholding the rule of law, and state cannot take a ground that it will result into burden upon the state exchequer. And this is no ground to refuse to implement the orders of the court. And dear friends, let us hope that now Maharashtra government also will implement various orders, including the orders of MAT, orders of Nagpur bench of High Court, and Aurangabad bench of High Court. Dear friends, let us hope that employees who are not aware, or the legal practitioners who are not aware of this principle or this law, that employee who retired on 30th June is entitled to get one annual increment, and if he is not aware, he can still approach the court and get the order. This will result into his enhancing the pension and also other retirement dues. So dear friends, this is a short information that I wanted to share on this platform today. So I have done it. Now for the day, I'll pause here. Thank you.